Rental providers, this information is very critical if you have a bad tenant or a tenant from hell, what we call in the industry. Now, again, this could be really counterintuitive, but a lot of rental providers have moved their management over to Jazz Real Estate, given our track record of VCAT wins and the cases that we have handled on behalf of our rental providers that have moved the management over. We are inundated with the phone calls that we're getting from lots of rental providers. However, we are selective in what cases that we will take on and on the basis of merits to ensure that the rental provider has also done everything in the right manner where there is a possibility and chance of having an ideal outcome from the VCAT or magistrates court. Please note, if you are a rental provider and you reside outside the Victorian state, you cannot apply a case or a hearing at VCAT unless you're in territories. If you are in a different state, your case must be applied and must be heard with magistrates court here in Victoria. On the contrary, your renter can actually apply with VCAT because they are within the jurisdiction of Victoria. Now, what are the important steps to follow when you have a bad tenant? Keep the record of each and every email and interaction. The interaction level must increase with that renter to be able to prove Section 330A. Any past history of the renter that can be included in the case, be it 1 or 2 years before as well, is super important, which means everything from the outset of your tenancy, start with the renter, or perhaps your next tenancy with a new or future renter, you must maintain a record and history of each and everything via email. Everything that happens should be on email on the record. You should not be accepting any maintenance request or any request made by the renter via phone or a text message. Critical. Emails are very important. You make the record and keep the records of everything. There's a lot of other things that we follow. On an average, if a case has to go to VCAT, on, let's say for an example, for rent arrears, there has to be a track of records that have been maintained, created, and also be able to prove Section 330A to be able to get an ideal outcome, apart from obviously the merits of the case itself. You must have issued the right notices with the right wordings. You must have attached the right documentation. You must attach all the information that is required by law with any notices to be able to have that notice valid. A lot of times there's cases where the rental providers go to VCAT waiting for 2 months or 3 months, in some cases a couple of years, to hear the cases and to find out that the case cannot be heard on that day because the paperwork submitted has defects in that. Let's say, for an example, there was a sale authority attached by a selling agency who was appointed to sell the property, and tenants were given or renters were given notice to vacate based on the property was being sold after the termination of lease. However, a VCAT member pointed out that on the authority itself, the agent has ticked that the property can be sold or will be sold subject to tenancy. There's two boxes on the legal sale authority. It's either property is being sold vacant possession or it is sold with the tenancy. You must always tick vacant possession because that authority went to the VCAT, and VCAT will take it as rental provider has agreed with the selling agent that the property can be sold with tenancy. VCAT questioned the agents who are representing the rental provider that they have expressed their intention that they will sell the property with the tenants or renters. Then why do they need access to the property, or why should the renters leave the property? In some cases, the renters have also advised to VCAT that they will provide access to the property for opens. What are the reasons that the renters are being required to vacate the property or leave the property? In those cases as well, VCAT has advised to the rental provider and the agent that the renters will be allowed to stay there. Bizarre, I know, but again, at the same time, this is how sometimes happens if your paperwork and your facts are not correct. Best option is that you have all the evidence to show to VCAT and ensure that you have all the reasonable rights and you've made all the reasonable steps to be able to provide the information to the renter that why the property is required to be vacated. Let's say, for an example, you want to stage the property, you want to do some cosmetic changes to the paint work, for an example, or you want to do some minor renovation to the property. That's why you want the renter to vacate the property. Not saying that you should do that. However, these are few of the options. Ladies and gentlemen, if you have a renter who you think would create issues if and when you serve a notice to vacate, be prepared. Prepare in advance, months or perhaps a year in advance. Thank you.